All right, the question of the day is a two-part. This is the NVAR residential sales contract. And one question was, what happens when I can't get a clear title? And we'll talk through what that means as far as what clear title means. And we do have a paragraph on it. And over the years, it has matured and gotten changed a little bit. And I don't like what they did. I don't know, probably two or three versions ago. They took out a time period in clearing the title. So let's start with that. Title is how we hold property. Buyer will promptly order title report. So in this paragraph, there are a lot of responsibilities for each party to do A, B, C, D. So the buyer is supposed to order the title report early on. Fee simple title to property and everything that conveys with it will be sold free of liens. Bang. That's an issue that we had come up this week where the property they're about to take on is not free of liens. They have a lien that was supposedly paid off, but the title is showing that it's still there. So we have one where there's a lien that is still showing up on the title, except for loans assumed by the buyer. Well, this loan that is on the title was from a loan. This lien that's on the title was from a loan many years ago. The seller says, I paid it off. Okay, so there's a payoff, and we're looking for payoff paperwork from the lender, but then it still has to go to the court to be cleared. So right now it's a cloudy title. It is not free of liens. Now they could argue that, but the lender's telling me that it's been paid off. Right, but there's still this cloud on the title.
Yeah, the
Um,
lien.
it says the seller will convey title that is good, marketable, and insurable with no additional risk premium. So what's the additional risk premium? Uh,
The lien.
what's that?
Will the lien be the risk premium?
Well, the risk premium could be, well, we can clear this, but you need to pay X amount of dollars to um, to get this done. And in a case that came to my table today, they said, yeah, it's good, marketable, insurable with this insurance policy. So now the buyer's going to have to pay two or $3,000 more. So it's violating this paragraph, and that's what I'm getting to. It's violating this paragraph. There is no, and if you can't, then we will void. I think that's a mistake here, but you can base your voiding on this paragraph. It just doesn't say in here that you can void. But if the seller cannot convey title that's good, marketable, insurable, and I've had some come to us where there was nothing on the title, but the title company couldn't insure it. Well, bang, deal's over. Okay? You can't if the seller can't perform this paragraph, you have a means of you have a voidable contract, I think. Title may be subject to easements, covenants, conditions. That's what they're saying there. Um, and then it says buyers advised to seek the appropriate professional advice. Seller will pay any. That's all that. What I wanted to focus on was, is the seller giving us a title that's free of any clouds? It doesn't have anything on it that's stopping the sale of it or making it a problem for the buyer in the coming years. Any comments on that? Anyone have had that run into that in the past?
Um, I, I
Yeah,
did in
Laura.
Pennsylvania. I did in Pennsylvania. There was a loan that the seller said she had paid off, but there was no proof that she had paid it off because the different banks were out of business. So
Yeah,
she had
boy.
to, and it was, I think it was a balance on it of like $89,000 or something like that. So
Hmm.
she had to put the money up with the title company so that they could give her clear title. So if they couldn't find it, it was paid off. That money would then pay off loan. But they did eventually clear it. You
Hmm.
know, we had to do a lot of research to find out the bank and end up being Wells Fargo has sold it to somebody and then somebody else has sold it to somebody. But it was a lot of fraud in there. So
Wow.
they eventually cleared it and she got her money back
Do you know how long it took to clear it?
a year. A
Well,
year.
at least this title company did tell our agent, hey, look, this could take months to clear it, but this
Right.
title insurance will allow you to be there in in confidence that it's going to get cleared. The buyer's like, but you're not guaranteeing it, and that's the problem they're having. If you're not guaranteeing that you can do this, and this is where when you have a listing you're taking and people are saying, yeah, I had an old loan and I paid, I say, do you have a payoff on that? You want to see the payoffs on any loan that your sellers have taken on that. It could be a home equity loan. It could be the first loan and they refinanced out of it. The title company is supposed to ensure that it gets that when they're doing a refi, that it's going to the mortgage broker and that they're getting a payoff and that it's been recorded at the courthouse. So that's some challenges there.
Yeah, because that's a lot of money
Yeah,
to put up, but
Anthony.
she had to put that up out of her proceeds.
I know that's crazy.
Yeah.
That's Pennsylvania, and apparently they allow that in that contract. Yeah, Scott.
I didn't chime in, but
Oh, sorry. Okay.
no, I actually had something else that was related,
Yeah, go ahead.
not about the lien related to mortgage, but a judgment lien on
Oh,
property that I was selling. My client had paid it off, and the judgment lien had never got released.
yeah.
And so we had to track down the judgment creditor in South Africa, believe it or not, and get that pulled. But that, that was clouding the title on the property, just
Right.
like an unpaid mortgage.
Yeah. Melanie, you got a point or question?
Yeah, I'm in a situation now with a deed of trust that was not released from a loan back in 2006, and the title company told me that they had to outsource it to a third party to track down the release, and they just notified me this morning that it will not be, they won't have it until February 27th. Meanwhile, we should have closed on the 4th. So
Yeah.
I'm like, is there, I
I'm
don't know
not
if there's
laughing
anything
at Melanie.
that
I
I
just
could
want to let
do.
y'all know she and I have had discussions on this. She has gotten 5 years of real estate experience in the last 5 months. She has gotten, if you have an issue with a deal, she's gotten it, but she's gotten through them. You've gotten through them, Melanie, right? So, I mean,
Well, fingers crossed. Fingers crossed. I'm like, I need this to close.
she's calling
But,
her former employer.
yeah.
Can I come back? What's exciting?
Yeah.
Anyway.
So now I have to hope that
Yeah.
that the buyers won't balk. I mean, they're investors,
Right.
so it's not like they were planning to move into the house tomorrow. But
Yeah. So the challenge
still.
you have with these, and Alicia, I'll come to you in just a second. Here's the challenge you have when you're postponing it for them to fix everything. A, they might not be able to fix it for a year. Laura pointed that out. B, remember when you're going to closing, like let's say we're going to closing next week, and they have a problem clearing that title. And or let's say it's a day or two before, when that money comes to the table from the lender, if it's involving a loan, that money can only stay on the table so long. And then they have to send it back. So this is where the buyer has to make a decision. Am I willing to go ahead and close with all the shoring up that the title company and title insurance is going to help me and wait it out? Am I willing to give time to the seller? Because in this market, to give them time means I'm still first in line until we go to closing and postpone the loan until we get it done. Or am I just going to cancel it altogether? Alicia, and then I don't know who's raising their hand for Zemeck and Company, but Alicia, go ahead.
So I'm not sure if this falls under this, but I think it might. So I had a property that I had sent out one of the golden letters, right? Because I had a buyer that wanted to live in a particular area. And I got a call, and it was from an heir of this property. And she was like, well, we're putting this on. My dad just passed away. Okay. So it had went in the MLS the next day, but so there was something fishy with the call. And then we decided to make a sight unseen offer, got it for the right price and terms. And we were going through, and the real estate on the other agent on the other side, was like, everything's going, and all of a sudden he called me one day and said, there are 7 heirs to this property.
Oh, wow. Yeah.
And I said, okay. And he said, one of them is not happy. And I'm
Yeah.
like, that was the caller, I bet. So my buyer had to make the decision, hey, do I want to wait this out? Because they had to go to probate court because of it, right?
Mhm.
And it could have taken up to 3 months, they said, maybe up to 6. It ended up, he decided to wait. We ended up paying, I tried to get the, how you have to buy the extension for the rate.
Yeah. Yeah.
So he bought the rate extension. I ended up covering it because the other agent was like, we're not doing that because you did this. We can just always go back on the market.
Hmm.
Well, the lender and I decided to cover it together. That's
Right.
what we did. So, and then we kind of, I guess we got bet on it going in a month,
Mhm. Yeah.
risky, but it did go in a month. And because my buyer had time and it did go in 30 days. And so we were able to close and clear the next month. But that's kind of scary, if you don't
Yeah.
have a lot of time or you don't know how long it's going to be and all that kind of good stuff. So, does
And
that
that's
fall
a,
under this or am I out to lunch here?
no, I was just going to say, that's a good example of, as realtors, we can't fix it. All we can do is give our options to the buyers and sellers. And with the buyers and seller, with the buyer, we just have to say, look, here's your 3 options. Hang in there and see if we can get it done. Let's extend the closing, okay, until they clear it. 2, pay these extra funds if that's an option for a policy that will protect you. 3, then you just get out of the contract and just give them the options of what they can do. But you were right. They decided to go, look, I like this house. And in this market, if you're the first in line, you're the first in line. And to say that we're having these legal issues up front is a reason to void. If the rest of the house is fine, it may be worth it to wait and work out all that detail. Okay, where are we going to stay for another month and that kind of thing. Megan, what was your question or comment?
Oh, I have a question. So I am dealing with a client who is trying to sell their home in order to purchase another home,
Mhm.
and as part of a divorce, a contentious divorce. And the husband is, there's a cloud on the title because he did not pay his taxes. And so we're waiting on the IRS to approve payoff at the closing.
Mhm.
I've been told by title that they give you like a date, they give you a certain amount of time period, and it was supposed to be yesterday.
They
Um,
who
that
the
the IRS will respond and
okay, yeah,
allow you to proceed within this time period.
right.
Obviously, that time period has extended now. That means that closing has been extended, and
Mhm.
we're waiting to close on her next home that she's buying because of
The
the proceeds. Correct.
seller A.
Seller A, seller wife.
Yeah.
So I have, well, 2 things. I've avoided at all costs telling we have a contingency that it's based on the sale of her home currently in
Yeah.
order to purchase.
Yeah.
But I was asked, why are we, because both are all cash deals. They're,
Oh, okay. Yeah.
um, I was asked why we're not going to closing, and title told me that I could say that there was just a payoff discrepancy
Yeah.
and it's none of their business, um, which is what I did.
Mhm.
But do you have any clarity or experience on how long these things typically take to clear?
Let me get my crystal ball out right here.
Well, they told us that it was like 2 weeks, and it has 2
Yeah.
weeks come and gone. And I don't know
And
if
I
that's
think,
because of the state of where we are right now in government,
right.
or if
And
it's,
it is a payoff discrepancy. It's
yeah,
just because it's the IRS doesn't make it any worse. It could be anything else. And at the end of the day, it's a payoff discrepancy. I would
right.
submit that if there's enough equity, it's not going to be a problem. You just want to make sure the IRS has removed that lien for the next purchaser for them to take the money and go do the other. Whether it's the IRS, whether it's a lien, and whether it's a mechanic's lien, I don't think it matters what it is. If it's a payoff discrepancy, it's a payoff discrepancy. I think you're fine. We don't have to reveal everything to other sides of the deal, and give them chapter and verse and everything. It's a payoff discrepancy. That's what we've been told by the title company. Please be patient.
But do you think that this is like a please be patient, like 2 weeks kind of thing, or is this like a please be patient months thing?
Whatever you've been given, I mean, this is different in that it's not a cloud on the title, it's just a lien. But if the IRS is saying, yeah, we can have this cleared up in a couple of weeks, then move it to a couple of weeks.
Right, but that's what they said, and now we're a couple weeks out, and it did not happen in a couple weeks.
Oh.
Now I'm concerned of how long it actually is going to
Yeah,
take.
then you may want to talk with the sellers and say, can I give a little more information? I have a tax lien on the property we're working out, and it's just a matter of that tax entity. It's a government entity, and they're not as quick paced as are you. And then because you need to let that buyer, let the seller of the replacement property that they may have to be waiting, and they may not be willing to wait. So at some point, you're going to have to reveal it's more than just a payoff. Because if I was the listing agent, this is more than a payoff issue. What's going on? And that's where you need to say, this is what's going on. It is a payoff issue. The payoff issue is a tax lien. And we're just trying to get word back from the agency. I don't have to say, well, who is that? The IRS? I'm not released to tell you that. It's just a tax issue. But it's taking longer than we thought on the tax. Would you still like to move forward? Because you probably still have the contingency on sale of home.
Yes.
Is there any other contingency like finance or
Finance, yep.
yeah, so you still got two other contingencies to get your buyer out without losing anything.
But the finance contingency will expire come Sunday.
Then you got to move it, extending that. And if they won't extend it, then you just say, we're out. Here's the void. Sometimes we got to void contracts for our clients, even though they don't like it. And say, look, you got to void because this is the worst thing that's going to happen if we don't void this. I had to void a contract twice before because the seller wouldn't move quick enough. I think I've told that story before.
Yeah.
And the seller asked, why do you keep canceling? So because you're not responding. And if you don't respond, my buyer is going to lose 20,000 or my buyer's on the dime to accept it the way it is. So we have a means of getting out and you got to exercise it.
Do you have any idea how long these types of things take?
That one I don't know. I don't know their whole situation. I don't know how old the tax is. I don't know if they're trying to get a payoff amount, which includes penalties and insurance and interest. I just don't know that. The title company would have a better handle on that, probably because they're the ones probably doing some runaround for the buyer, for the sellers.
Okay.
Sorry, I couldn't give you better.
That's all right.
Scott, you're muted.
Sorry about that. Going back to Alicia's situation, we ever get into a situation like that where it's an off-market property and somebody says it's parent died and would be interested in selling, we're able to ask for from that party a document from the court that would indicate that that person actually has the right to sell that property.
Yeah, definitely.
Before
yeah, you need
to start down the process of making an offer.
You're gonna when the court gives them the right to sell, there's an administrator. They can become the administrator. There's the, what do you call it? The person of the will, executor. Then there's an administrator. And sometimes they'll say, oh yeah, I've got the right to sell it because they asked the clerk, can I sell this property now? Oh yeah, you got a right to sell it. And I had this with a situation. And this is let's talk about the multiple heirs problem. Okay. The executor has been told in the will, you're the one to sell the property. It doesn't mean they have to get permission from everybody. If they don't have a will and an executor, and I'm not an attorney, and now they have to go to probate, you're in the you're going to run into, now I've got 4 heirs or 5 heirs or 7 heirs. And when you do that, now everyone has to agree. But that's where the head honcho or someone goes to court and says, Your Honor, I need one of us to be given the option and the right to make the decisions and not get sued on the back end because everyone thinks you could have gotten $50,000 more. So the administrator is not the one that necessarily signs one signature and it's done. My guy was the administrator. It had to go to probate, the apartment that he was selling. It was his brother's apartment who died intestate, which means out of a will. He did not have a will. The court said, okay, you're the administrator. Well, by the way, here's the 4 heirs. It was him, a brother, a sister, and a nephew. And so he was the one that was given the option, the authority to be the administrator, but he did not have one signature right. He had to get 4 signatures. And since they were like all over the place, he had to go get powers of attorney to sign for each one of them. Whereas an executor can go in, I'm signing, I'm the executor, it's in the will, it was already pre-agreed to. And so I can sign all the paperwork. I can list the property, sell it, and be the only one signing. This whole thing about I've got 7 heirs and one of them doesn't like it. I think I'm sorry I was just talking to about that. They said that there was 7 heirs because they were intestate. There was no will. That's the problem that might go on with that. I'm not sure if I'm answering your question, Scott, or not.
I didn't actually have a question. I was just wanting to
Oh,
make sure everybody knew that, in that scenario, that we certainly could ask whoever is representing, I have the right to sell the property.
Yeah.
Well, don't you
Or-
a little bit have to like assume? I guess I know that's a horrible word here. That if it's in the MLS, they have the right to sell it.
No.
No.
No, because sometimes the agents they're just not, and I don't mean this in a bad way. They're just ignorant of the law. They're ignorant of what they went in. They got a listing signed off. I mean, we have one right now where I don't know if it's us or one I just read that, you know, they got it on the market. It's in the MLS, and we get to trying to sell it, and we find out they only had one party sign it, the listing agreement. It was a husband and wife that were estranged. And the agent was just thinking, well, I'm just a really hard-working agent. I get things done. Well, you just did things wrong. You can't do things wrong and you can't assume it's right. That's why when I look at the tax record and I see that there's a different name than what's the agent's telling me, I need to say, where's your paper trail? I don't want to get my buyer wrapped up in this with their $10,000 deposit and find out later that the seller or all of the heirs are going to try to go after my guy's deposit because we didn't know something.
Well, that's interesting that you said that because I have a client here that has a Colorado property and they check it often and it was for sale without they didn't put it for sale because a realtor got listing paperwork signed by people who did not own it.
Yeah.
So that's so interesting. I mean, like, are we going to have to check everybody?
Well, in fairness, the reason I brought that up was, Alicia, you had mentioned in this situation was a golden letter went out, and then someone contacted you and said, "Hey, my parent, whoever, passed away, and I'd be interested to sell." And then an agent got involved on that side. Just in that scenario, you would have a little bit more knowledge than the normal situation that or at least have reason to think that there was an estate situation. In that case, you could ask for the document from probate saying whoever it is authorized to sell, real estate or this property.
And Alicia, you said it was land
Here or
in Colorado. It was
Colorado
land.
was land. Yeah.
Yeah. See, and Dave Robertson of Universal Title says that's the target right now is vacant land. People can pull down records, go in fraudulent. And he says it used to be all online. And now they're showing up at the table to sign paperwork with fraudulent IDs and everything. And so he was involved in a case where he just knew this doesn't sound right, doesn't smell right, reported it to the police. And the police says, yep, that's who we're looking for. And the police were waiting outside the door. And when they showed up and handed over the fake IDs, the police walked in and arrested them. right here in Fairfax with people that we know. This is not, some urban legend. So yeah, that's definitely what can happen there. Anything else on title? All right. So the next one I want to talk about is what if the seller doesn't want to sell? Usually it's the seller that would push in this next paragraph. And it's the default paragraph. We kind of understand what happens when a buyer is defaulting. That's usually I'm not going to closing, and there's so many things the buyer can do wrong. I didn't get my financing, I didn't get my insurance, I didn't get my title insurance, I just didn't show up, or whatever. There's a whole lot of reasons the buyer cannot show up to sign. They're get cold feet, and then the seller says, "Great, I want your deposit." It's not as much on the seller side that we see this happen, but it can happen that sellers back out. Now, the first thing you need to know on this one is back to what we were talking about with title and heirs. Let me just search heirs. Yep, heirs. There we go. Back with them. Okay. So in the entire agreement paragraph, let's start with this one. All contracts for the sale of real property, including any changes or addendum, must be in writing. Contract will be binding upon the parties and each of their respective heirs, executors, administrators, successors, and permitted assigns. That line right there means when the seller or the buyer passes away, the heirs have to carry this out. Now, the challenge for the buyers is that when the buyer passes away, unless it's a cash deal, most likely the ability to perform dies with the buyer. So usually the buyer gets out because, well, there's no money to borrow. The loan gets canceled, and so okay, that contract's dead. The seller may make a claim that they're going to get the earnest money deposit, but I think it'd only be a seller without a heart, Mr. Grinch, So anyway, but the respective heirs, executors, administrators. So with a seller, even if Mr. or Mrs. Seller die, they still have to move forward by the way this contract is written. Doesn't mean they can't ask, hey, look, my spouse died and we were going on to go buy something. We are not doing that now. I need to get things together. I want to cancel the contract. They could do that, but per the contract, the seller could be sued by the buyer to finish it because you're just the respective heir per this contract. And I'll tell you this about courts, and Scott, you can back me up on this. He's the attorney in the room. They don't go by feelings. They don't go by what's fair. They just say, this is what the contract says. Okay. So I say that to then go up to 26 or 25 about default. When the seller says they won't perform. If seller fails to perform or comply with any of the terms and conditions of the contract. So think about the paragraph below in paragraph 30. Why are they not performing? My deal fell through somewhere else. I just changed my mind. We had an argument and now we don't want to move. Something happened with my family plans, whatever. The sellers decided not to perform. Whether it's default by buyer or seller, the seller will be in default if we'll have the right. If either buyer or seller, then in addition to all of their damages, the defaulting party will immediately pay the cost and incurred for title examination. This is where the buyer could sue for performance. And this is not small claims court. This would be going to district court in Virginia, where they hire an attorney, they pull them into court and say, they said they would sell, and I'm going to sue you to perform. And this is where I read recently on judgments, and say, well, you can sue them and get, $100,000. According to this information that I read, which was with a an association, a national association, 80% of judgments don't get paid. Okay. So that was aha to me. Like, well, you could sue them, but 80% chance you're not going to get anything. On this one, this will happen because the judgment not being paid means someone's not writing you a check. On a judgment on this, when you're selling a house, the judge will force them to sell the house. And if they have to, they'll turn it over to the court to sell the house because you're in the middle of a contract that you've already agreed to. Okay. So you can force someone to sell. You can force the buyer or the seller to the table. The question is the buyer or the seller that wants to sue, are they dedicated to the process? It's going to get really expensive to do that. And so just keep that in mind that this would be a place where they sue for performance to move forward on the sale of the property. Any questions on that? Any comments?
No, the only comment I'd have, Anthony, is this. I mean, if you ever get into a situation where we're representing a buyer and the seller, wants to take a powder, and for whatever reason, the leverage that a buyer has with this language is extraordinary. You, as a seller, you would have to be off your rocker to try to fight this because you're going to lose, you're going to be evicted by the sheriff, and you're going to owe all attorney's fees.
Yeah.
And other costs too, because it's the specific performance is not just get into the house. It's if the buyer has to spend 6 months in a rental.
Right.
That's all good. So that's a tremendous amount of leverage to put upon a seller, even if they make that initial representation to have, a come to who discussion about here's what you're looking at.
Yeah, this is the what I highlighted there. The buyer seller will be in default and buyer will have the right to pursue all legal and equitable remedies, including specific performance, just getting them to sell, and or damages. If either buyer or seller is involved, then in addition to all other damages, the defaulting party will immediately pay the costs incurred for the title exam, the appraisal, the survey, and the broker compensation in full. So it gets very expensive. And so I've had to pull this out a couple of times with buyers and sellers to say, you need to understand what you're up against here. And you're going to have to pay for all these expenses, and the broker could go after you for compensation because we're like 2 days to closing, and now you want to yank it out from underneath anybody, a legally binding document. And then the other piece would be, the damages. I rented a moving van. I sold my house. I've been in a hotel. Those are damages that aren't cheap. So those are the other items that you could go after. And I'm not trying to, it's not a scare tactic to tell the buyer or seller, this is what you might face. It's the contract that they agreed to. They said they would do it. And this is going to be held to you accountable if you don't go to settlement. If you can't get a release from the buyer or a release from the seller, then you're going to be on the dime not only to buy it, but now you're going to have this big legal bill and damages if you cost them more money to stay in place or to have to go rent somewhere. So that's all I got for today. Any other questions? Anything going on?
I think one of the pieces that not many agents realize is that on that default provision, who either party defaults, they owe the brokerage fees to both sides. Now, the other side could decide, well, I'm not going to try to collect that from my client.
Here's the thing. And I've just thought of this as we started going through this past our new way of doing things. The broker compensation in full. Okay. Which broker are you talking about? Because now it's the compensation in this contract, which that might be, whatever, X%, certain number of bananas. But does that mean that the defaulting party is also on the dime? The way we've always interpreted it, because the broker compensation always flowed through the seller, the listing company, that's what you owe. I would submit that because that hasn't been rewritten, we're probably still talking about the compensation of both parties.
Or at a minimum, it's the non-defaulting party's brokerage is entitled to their fees at a minimum.
Yeah, that's a good way of putting it. Yeah. The non-defaulting. So let's say the seller's defaulting and we have to take him to court and win. But whether he pays his broker or not, That's on him, but now he pays the broker compensation for the buyer.
Yeah, and the other thing that I've had this happen twice with buyers in my career, when I was representing the seller and they wanted to walk. It's like, look, I told my client, I says, don't accept you want to pressure them to go forward with this. And it wasn't a fiscal reason they couldn't. They just, we changed our mind. Don't agree to accept the liquidated damages, the EMD. Point out to them, the buyer, that, hey, you're in default. When you go try to get a loan, you got to disclose you have a potential legal claim against you relating to defaulting on a real estate contract. See if you're going to get financing.
Yeah.
So it's a way to pressure a buyer to say,
Right.
look, you go forward with this, or you're not getting the house.
Well, I see what you're saying, because now you've got this legal
Yeah,
cloud
legal.
over you as a buyer
Yep.
to go try to get a loan on another house. Good point. So all these things that we're saying here is these are items that you need to keep in mind. Understand this default paragraph, understand the title paragraph, look at every little piece here that's required underneath it. It's kind of, I mean, if we bullet pointed it, it might be easier to understand, but it's all in just run-on sentences. You know, these would not do well in the English class. But because of that, you have to understand to the buyer or the seller, let me put this under your nose and show you what this is about. Mark up the contract, scan it, and send it to them. And say, look, I'm not trying. And sometimes the buyer or the seller say, you need to be on my side. I am on your side. I'm trying to keep you out of court, which gets very expensive. You go to court, I have to do this. I'm your realtor, but I'm not an attorney. I might be called in to testify, but I can't negotiate for you when you're violating this contract. That's me being in your corner. So that's how that goes. All right. Anything else?
Thank
Okay. All right, folks. 11:44. We've done good. Thank you very much. I appreciate y'all coming on board. And
Thank you.
Thank you.
you.
Thank you, Anthony, as always.